The court's in receipt of a proposed amended complaint. Detective, if you'd raise your right hand. Do you solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
All right, put your hand down. Your name for the record, Detective?
Detective Meckel for the Royal Oak Police Department, Your Honor.
All right, go ahead.
Before you this morning is a 7-count warrant charging Joshua Scott with delivery and manufacture of methamphetamine, delivery and manufacture of Schedule 1, 2, or Schedule 3 controlled substance, carrying a concealed weapon, possession of a controlled substance less than 25 grams, and 3 counts of felony firearm. The facts of the case are documented in Royal Oak Police Report number 26-5316 and summarized as follows. Excuse me. On 2/26/26, ROPD officers were dispatched to Hotel Royal Oak, located at 811 East 11 Mile Road in the city of Royal Oak, County of Oakland, state of Michigan. Officers were dispatched to the area for report of a potential domestic argument coming from one of the rooms. Officers arrived and observed loud yelling to be coming from the northwest corner of the complex and a male walking towards them. The male verbally identified himself as Scott to officers. When officers began to speak with Scott, he stated that he had gotten into a verbal argument with his girlfriend and that she had broken into their hotel room. He reported that she was intoxicated as well. Officers asked for consent to check his person for weapons, and Scott agreed. Officers felt the bulge consisted with a firearm in his right pants pocket. Officers asked Scott if he had a firearm on his person, and he stated he did and that he had a valid CPL. Officers removed the weapon from Scott and secured it with his permission. Further, $6,000 in cash was located in his left pants pocket. A lean SOS check of the firearm showed the firearm was stolen in December of 2025 in the city of Detroit, and Scott did not have a valid CPL. Scott was placed under arrest. On Scott's person, across his body, was a black sling bag as well. The bag was taken from his person and secured with his property that officers taken custody of. Officers spoke with Journey Hudgens, Scott's girlfriend, who was standing in the doorway to room 121 and yelling when they arrived. Hudgens stated that she had been in the bathroom crying and arguing with Scott. She threw paper at him, and he proceeded to throw her out of the hotel room into the parking lot. She then broke in through the window due to being thrown outside in minimal clothing. Hudgens had scraped her knees and elbows and had visible injuries. Hudgens adamantly denied wanting any criminal charges against Scott. Once at ROPD, Scott's property was searched. In the black sling bag, the following was located: 61 grams of suspected marijuana individually bagged, approximately 48 prescription pills, approximately 4.7 grams of suspected cocaine, approximately 19.5 grams of suspected ecstasy, numerous Ziploc bags, a working digital scale, latex gloves, and an air tag. The suspected narcotics were submitted to the Oakland County Forensics Lab for testing, and the following was found: the suspected cocaine tested positive for cocaine, the prescription pills tested positive for amphetamines, the suspected ecstasy tested positive for methamphetamine. A MAPS report was conducted on Scott and shows no current prescriptions. Net Officer Bunting reviewed this report and found it consistent with the practice of delivering narcotics. I believe the information provided is sufficient to prove a probable cause stand. The alleged criminal offense was committed by the named defendant. I have affixed my signature to the criminal complaint and respectfully request the court execute the warrant in this matter.
All right, the court does find that the detectives met his burden. I will sign the amended complaint and amended warrant here today. Detective, I think probably need you to stop by at some point and sign the complaint too. I don't have your signature.
I actually just uploaded the digital signed one to the Oak video file. I just didn't get it done in time. I'm sorry about that.
Very good. I'll wait for that one then and sign that when I receive it. As to arraignment here, Mr. Brown, any comments regarding that? Waiving the formal reading on the new charges?
Yeah, we'll waive the formal reading of the new charges and ask for a plea of not guilty to be entered.
All right, court will enter a not guilty plea on behalf of Mr. Joshua Scott. Do either party have any comments with regards to bond? The court's inclination is to leave bond as it currently sets at $25,000 cash surety, no 10 with the conditions, unless there's any other comments from either the people or defense.
Judge, we would ask there be no increase on bond. This is the same transaction as Mr. Scott is currently incarcerated for. There's just a minute of the complaint. We were seeking to address bond, however, to have a reduction of bond. I'm not sure if now was the appropriate time to address that bond, but in response to the new charges, we would ask for no additional increase.
People?
Your Honor, I take no position on the increase, but I would object to any decrease in bond considering the amended charges and the history here, Your Honor. and the court, I'm sure, is aware, he was out on probation when this incident occurred.
Right. Mr. Brown, I don't want to stand in the way of you making a record if you want to make that request. Did you want to add any additional comments?
Yes, Judge. As far as a reduction of bond, the purpose of bond is twofold: one, to protect the public, and two, to ensure that Mr. Scott returns to court. I'm unaware of any capious history failure to appear on Mr. Scott's part. He has retained counsel, and he takes his charges very serious. And I know as far as the danger to the community, I don't believe that Mr. Scott poses any danger to the community. These are no non-assaultive crimes. I know there was an indication or accusation that there was some type of physicality allegedly between Mr. Scott and his friend. However, that no charges were brought forth due to those accusations. Mr. Scott has been employed. He's currently employed. He does have family support. His father is on. He has ties to the community. Judge, we would ask for, at the very least, a 10% provision of the bond of $25,000 that Mr. Scott could be able to make bail, assist in his defense. He does also have dependents who are financially dependent upon him and his paycheck, so he can go home and continue to support them. So we would ask for that reduction in bond, please.
All right. Anything else you wanted to add, Ms. Ayub?
Your Honor, again, I just reiterate for the record that he was out on probation when this incident occurred. He was out on probation for also weapons charges. I think it is a danger to community, and I'd ask that there be no provision on this. I'm not asking for an increase, but I don't think a 10% is appropriate.
All right. The court does have some additional information here regarding Mr. Scott's history. There are 3 active bench warrants as of the printing of this report on March 2nd for traffic offenses, and then a violation of probation warrant is out as well, at least as of the 2nd of March. Given that and the seriousness of these charges, the fact that they deal with serious narcotics, a large amount of them, along with felonies, and there is some allegation of some physical altercation at the time of the offense as well. The court will not find that the arraigning magistrate abused their discretion at the time of setting the bond, and will leave it as set previously with all of those conditions remaining in place.
At the end of the bond argument, the judge ultimately decides not to reduce the bond, keeping it set at $25,000 cash along with the previously imposed conditions. The reasoning behind that decision appears to hinge on several factors: the seriousness of the narcotics charges, the presence of a stolen firearm, and the fact that Scott was reportedly already on probation at the time of this incident. From the court's perspective, those details raise concerns about both public safety and the defendant's reliability in following court orders. And when judges evaluate bond decisions, those 2 considerations, community safety and ensuring the defendant returns to court, are always at the center of the analysis. Now, the case moves toward the preliminary examination, where prosecutors will need to show enough evidence to move the charges forward toward trial. But what do you think about this decision? Should the bond have been reduced, or did the judge make the right call keeping it where it is? If you found this courtroom breakdown interesting, make sure to hit the like button, share your thoughts in the comments, and subscribe for more real courtroom cases and legal analysis.
All right. We are here. Thank you for Detective Meckel. I don't think we need you anymore unless you want to stay.
No, I appreciate it, Your Honor. Thank you.
All right. We are here for a PCC. How are we proceeding on that today?
Judge, we would like to set an in-person preliminary examination. It's my understanding that the court may be busy within the next week. However, I did speak to Mr. Scott, and he is asserting his right to have his preliminary examination within 14 days. Within 14 days of the arraignment per MCR 3.953D.
One moment. Just looking at dates next week. Could we get him here that quickly? We're good. It's Monday. All right, so a couple options. The 19th we could do right at 1:30 also. A little later. Okay. So we have the 16th Monday at we could get started a little later in the morning. We have the 19th in the afternoon, get started right after lunch. And then we probably could do the 20th later in the afternoon.
I'm sorry, Judge, I have dockets on those dates. I'm not available. I mean, I could probably try and make the 19th in the afternoon work. But we're short staffed, so I can't even get someone here to cover, and those are non-state days.
What about the 20th later in the afternoon?
I'm also not available that day, Your Honor.
Okay.
And Judge, 19th, I could make the 19th work. I believe the counsel did indicate there's a possibility that she might be able to make the 19th in the afternoon. I also could make the 19th in the afternoon if that is good for the court.
Otherwise, we'd be going out until the following week, the 27th.
Your Honor, if I'm not mistaken, since he was rearranged on the new charges, I believe the 27th would still be within the 14 days.
All right. Are you available on the 27th, Mr. Brown?
I have a motion hearing at Third Circuit Court at 12:30. So if it's the 27th, it would have to possibly be in the morning. And I may be in trial. I don't think the trial is going, but I have a capital trial could start on the 23rd, but it's dependent on whether or not my client takes an offer today. So
we can do on the 27th, we could do 10:35 in the morning or 1:35 in the afternoon.
I'd probably say 10:30, 10:35.
All right. I think that's still within guidelines, and prosecutor obviously has some conflicts, and she's correct that our state days here at the district court are Fridays, and that's the day that we have the Oakland County Prosecutor's Office. So I'm going to push it to the 27th at 10:35. And if there's any issues between now and then, obviously just reach out to the court, and we can try to make this work. Okay.
Okay, thank you.
All right. You're all set for today.
Okay.
You all set? I believe.
Yes, you can disconnect.
Okay, awesome.
Take care.
Yeah, you too.
Max, were you able to talk to your client?
I was, Sarah. She is on Zoom under the name Digi Dollars. And she would like to adjourn today's hearing to possibly retain an attorney.
Be right back. Oops. Mr. Canis will be with you in a moment, okay? Ms. Petties, am I saying that right?
Yes.
22-00674 SD, People versus Kristen Petties.
Fair use on behalf of the people.
And good morning, Your Honor. Max Manugian appearing on behalf of Kirsten Petties. Ms. Petties, please state your name for the record.
Kirsten Pettis.
All right. Date and time for a pretrial. How are we proceeding today?
Your Honor, I've spoken with the prosecutor. There is an offer on the table. I have had a long and productive conversation with Ms. Petties related to that offer. At this time, she would like to ask for an adjournment of this matter. She wants to weigh her options, possibly retain an attorney.
Any objection for the people?
No, Your Honor.
All right. 30 days long enough, Mr. Manugian?
Yes, Your Honor.
All right, let's set this out 30 days. Should give you enough time to consider all of your options. Ms. Petties, we'll see you back here then. Your bond's continued. You'll get notice of the date and time in the mail, okay?
Okay, thank you.
All right, take care.
Thank you very much, Your Honor. Have a great weekend, everybody.
Thank you.
You too.
So did you get the signed copy of the warrant?
No, that was just what was in my file. I just wanted you to be able to have it, to see it. But no, I don't have a signed copy yet because he uploaded it like as he was logging in.
Okay. Will that come to
Yeah.
you or to us? I don't know.
It should come to you guys.
Okay. Gotcha.
I think. I don't know. Let me ask him.
I'll just hang on to this one until we can figure it out.
I don't know if it gets sent back to my office and then my office has to do it. I'm finding out.
Okay. I'll just hang on to the file for now.
Okay. He said he sent a copy to the court through Oak Video, so you guys should have it.
Okay. That's good. Thank you.
Mm-hmm.
Morning, Mr. Gagnick.
Good morning.
Mr. Davenport.
Yes, good morning, Your Honor.
Morning. It looks like your client is here from a video connection. Did you want to speak with him or speak with the prosecutor first?
I'd like to speak with my client briefly, if that's okay.
Yeah, no problem.
Thank you.
Mr. Tabron?
Yes, sir.
Okay, good morning. I'm going to get you into a breakout room with your attorney, Mr. Davenport, okay?
Yes, sir.
Good morning, Miss Blakeney. I'll get you in line to see Farah, okay?
Good morning. Thank you.
Did you need Mr. Canis in a breakout room?
No, I'm ready on both. Whatever order the court wants. I'm not in any rush. So
Okay. As soon as
whatever works best.
Farah gets back in here.
That's fine. We're gonna set crack the old